Hi, this is the Business Guy. So is asset protection legal? There are those who view asset protection planning with skepticism. They think that others have legal obligations to pay their court-ordered debts. If a judge says they have to pay, they argue, they should strip their bank accounts bare, turn over their dwelling places, their vehicles, take the shirts off their backs, and live in the streets with their private parts covered with fig leaves until they pay their debts. Examine the facts, however, and that perception may change. Look at how many 5-4 decisions there are on the 9-member Supreme Court. A judge who rules one way could just as easily have ruled another. Judges are human beings just like you and me. And just like you and me, they are subject to external pressures that may influence their objectivity. Supreme Court Justice Antonin Scalia said, "A creditor has no cognizable interest in the assets of a debtor prior to obtaining a judgment. Anyone can transfer their assets all day long until the sheriff shows up with a writ of execution pursuant to a court order." By the way, if you appreciate this information, please click the like button below so YouTube promotes this video. Thanks so much. And you can also click the subscribe button below if you haven't already, so that when more videos come out like this one, you'll be up to date right away. So is asset protection immoral? I've heard the weakest arguments against asset protection from lawsuits. If someone says you owe money, you should pay it. Asset protection is thumbing your nose at the judiciary, and so on. What if it was your money we're talking about? What if it was your opponent that got up on the witness stand and lied until he was blue in the face? What if the judge believed him? Are you going to feel warm and fuzzy about emptying your bank account for the benefit of a deceitful fabricator? Of course not. Is a U.S. person driving a Toyota thumbing your nose at the American auto worker? No. When you buy a Toyota, you're not really thinking about your thumb or your nose or whether those two body parts come in contact with one another. You may choose a Toyota because you feel it best meets your needs better than any other available options. We live in a free country. We get to choose which car best suits our needs. If you feel that a Honda serves your needs better than a Chevrolet, that's your choice. After her 6th drug relapse and 3rd affair, she moved in with her drug dealer boyfriend. One of my employees, a wonderful husband and father, was left alone with their 2 children. Naturally, the 2 divorced. Should he be obligated to fuel her addiction every month? Keep in mind, your money is your money. You get to do with it as you please. You have auto insurance, you put on your seatbelt, you lock your door at night. You do all these things to protect yourself and your valuables. Likewise, you may feel it is in your best interest to keep your money in an international asset protection trust. You decide that if you leave your money back home, it will vanish in a lawsuit. Hey, it's your money. It's your choice. After all, we don't live in communist North Korea. We have freedom to do what we want under the law. A case for asset protection. I've been in the asset protection business for over 30 years, so I can personally attest that a close decision could be swayed by whether or not the judge and one of the attorneys happen to play golf at the same country club. One attorney we know invites several judges and other attorneys to his house each year to watch the Super Bowl. Another attorney has a judge as a fishing buddy. It's up to the judge's discretion to recuse himself from the case. Still another lawyer and his wife take regular vacations with another couple, one of which is a member of the judiciary. Yet another we know is the son of a former law partner of the judge before which he tries cases. Still another attorney was the law clerk or assistant to the judge. Judges are not emotionless robots that make decisions based on pre-programmed inputs. They have good days and bad days, flat tires and birthday parties. The doctor just diagnosed his wife with cancer. His 15-year-old golden retriever named Drake died last night. The roof on her house has a serious leak. His court secretary's baby got sick and couldn't make it to work, leaving him overloaded. These personal relationships and life circumstances can readily alter judicial outcomes. The rising tide of litigation. This is not to mention the ever-rising number of lawsuits. A noteworthy example is the predatory behavior of the businesses that file lawsuits to stifle competition. Cisco sued Innovato IP Ventures, for example, forking out over $13 million in legal fees to attack its competitor over a patented product that ended up being worth a mere 10 cents per device. They spent 5 times what they ended up settling for. They didn't care. The lawsuit was an attempt to squash a competitor. Patent trolls take advantage of loopholes in our patent law to extort small businesses and make a quick buck, said U.S. Senator Amy Klobuchar. The explosion of frivolous patent lawsuits punishes innovators and drives up costs for consumers, which is why we need legislation to crack down on bad actors while preserving patent rights that are vital to innovation and competition, she added. Moreover, defendants face ever-broadening theories of legal liability. Often one person pursues another because the plaintiff sees the defendant as a person of substance substance. Likewise, Robin Hood judges rule against the defendant because it appears that would be easy for her to pay. Besides, the poor pitiful plaintiff is such a nice person and could use a helping hand from the rich business owner. What we are covering here: first, we define asset protection. Next, we'll show why whatever asset protection you now have is probably not adequate. Finally, we'll show that it is perfectly legal, moral, and ethical to protect your assets from current and future creditors, unscrupulous attorneys, and con artists who manipulate the legal system for their own benefit. So what is the definition of asset protection? Asset protection, known as creditor-debtor law, is a legal means to shield personal and business resources from civil judgments. The objective of asset protection is to shield wealth from the demands of creditors without perjury or tax evasion. Asset protection is a simple and warranted part of financial planning. People employ asset protection plans to help protect their hard-earned wealth before or in the presence of a legal threat. Naturally, the earlier you put such a plan into place, the better. Why do I need asset protection? One substantial benefit of asset protection is that it puts one in a position of strength when negotiating a settlement. Plus, we've seen countless instances in which it has prevented litigation in the first place. We have even seen plaintiffs drop cases midstream when they come to the stunning realization that they will be stuck with a pile of legal bills and nothing to show for it. Conversely, asset protection planning is not about evading taxes, secretly shifting assets to family members, or defrauding others. Asset protection tip: you can best defend your plan when you have established it well in advance of a claim. Now, building a fortress when the bullets are flying doesn't quite go as well as establishing the structure before the onset of war. Now, there are still effective ways to protect oneself after a claim has arisen. However, pre-planning trumps last-ditch efforts. Okay, why conventional asset protection doesn't often work? Almost everyone has engaged in some form of asset protection plan. The most familiar types include insurance, car insurance, fire insurance, an umbrella policy, malpractice, health, etc. The sad fact is that such insurance can actually increase the chance of a lawsuit, not decrease it. We can collect the insurance money plus a whole lot more, a contingent fee attorney says. Increasing competitive pressure to decrease insurance rates fuel the prevalent exceptions written into today's insurance policies. Plus, if the plaintiff raises the fraud word in a filed complaint, justified or not, the insurance company will usually tuck tail and run, refusing to defend the case or pay any proceeds. Companies. Other prevalent asset protection tools include the use of corporations and LLCs to separate business liability from personal. If properly established and maintained, a corporation may protect personal assets from a business lawsuits. But take your spouse out for dinner on a Friday night and rear end somebody. Then that same somebody sues you for more than your insurance covers, and you have another problem. When somebody sues a corporate shareholder, the shares of stock and the assets inside of that company may be taken away. If the principals did not adhere to the proper formalities, such as minutes for the meetings, resolutions, etc., his opponents may pierce the corporate veil. Thus, his creditor may rip the shareholder's personal assets from him in the event of a corporate judgment. Statutory asset protection. Lastly, some states let its citizens shield assets through various forms of ownership. Tenancy by the entirety comes to mind. The homestead exemption of a primary residence is another. But what if one spouse dies suddenly? What if both spouses have judgments rendered against them from the same creditor? That asset protection may disappear. Retirement assets, such as IRAs and 401ks, may enjoy some protections. See our article on IRA creditor protection by state. The value, size, and location of a personal residence affects the homestead protection. Even the homestead laws in Florida, considered generous, can go out the window if the home is in a city and sits on more than 1/2 of an acre, or may be severely limited if forced into bankruptcy. Asset protection tip. Though the asset protection is limited, it is still wise to use conventional asset protection to supplement your master plan. Though it won't protect you from all risks and the protections are limited, have adequate auto insurance, health, and other appropriate insurance. Use limited liability companies to protect against a business lawsuit and to help protect business assets from seizure in a personal lawsuit. Take advantage of various forms of ownership, such as tenancy by the entireties for married couples in states that offer that benefit. The title document should clearly specify tenancy by the entirety and not joint tenancy. Be knowledgeable of the assets that are exempt from judgment creditors in the state in which you reside. Know the extent to which your state laws protect you and take measures to protect yourself beyond these limitations if needed. Asset protection is moral, legal, and ethical. Properly done, asset protection plans are perfectly moral, legal, and ethical. There are perfectly lawful mechanisms that can be employed to protect assets in a manner that coincides with ethical protocol for professionals and their clients. We might add that these tools should be put into place by members of the public and their counsel as an act of prudence, principle, and sound fiscal judgment. In a country with 4.4% of the world's population, 80% of the world's lawyers, and 96% of the world's lawsuits, it would be unwise to walk into the U.S. business world without such a shield of protection. Protecting oneself and one's client is the right thing to do. Done properly, asset protection should be conducted in a legal and ethical fashion. It must not be used to aid in protecting assets from criminal or fraudulent activity or to engage in tax evasion. Limitations of asset protection attorneys. One can protect himself or herself at any stage in the game. Attorneys, however, can run into legal or ethical issues by helping clients under the following circumstances. The client will inevitably has or already has been sued. Bankruptcy has been or will be filed. The client has not paid his or her tax bill. A client is under tax audit. The client will be insolvent after the plan is put into place. The above are reasons why an asset protection company can help in certain circumstances where a legal professional cannot. Doing so must be within the bounds of the proper legal framework. Working with such a company, even with the tangential support of a law firm, must be a proper course of action. Do it now. Here's another asset protection tip. Putting together an asset protection plan is not a do-it-yourself endeavor. It requires specific guidance from a professional who knows the safe zones and the landmines. Attorneys and other associated organizations dare not tread if the client seeks to protect from illicit gain. Be aware of tax, bankruptcy, fraudulent conveyance, and other implications. Professionals should employ know your client strategies, identifying and verifying before proceeding. Asset protection conclusion. You may have one of the most cautious personalities on the planet, driving like a nun and coloring within the contractual lines. There is nothing you can do to keep the other guy from suing you. Nothing you can do to keep a heartless lawyer from trying to put food on his or her own table by taking it off of yours. Nothing you can do to prevent a competitor from using the law to try to squash you. The better you do financially, the bigger the target on your back. Asset protection works when you do it right. So it's up to you to gird your loins with adequate armor. Asset protection is legal, moral, and ethical. We might add essential as part of your overall financial plan. People who do not put such a plan in place and professionals who do not advocate it are doing themselves and their clients a great injustice. Asset Protection Planners is part of an organization that was established in 1906. I believe we have over 80,000 clients in our database and are the nation's leading asset protection firm. So give us a call if you want to set up an asset protection plan, and please click like, subscribe, and share this video. See you next time. This is The Business Guy.